Thank you very much. Now, there are a couple of things I think that would be an important segue into this discussion. One of them would be that actually Andrea in his speech mentioned a part of it. So there is a perception that there are so few rejections in the merger control field anyway that there shouldn't be that big a deal. I'm not saying that's how he said it. This is a view. He gave a parameter. That's why I'm referring to Andrea Petroli. He said 39 rejections out of 10,000. There is something there. So in one hand, we should all think about that. Are we crying wolf where there's no wolf, right? It would be natural for me to cry wolf if someone is going to, because I've been involved in almost all of these innovation theories of harm in merger control cases. And you could be blinded that way because you have done too many of them. You might be feeling this is happening all the time. Also, my academic work is on this. I wrote a book on this, so naturally, I do feel that there is an issue here. And how I reconcile this in my mind with what Andrea has said is, while it may be true that 39 cases out of 10,000 are blocked and fewer on account of innovation theories of harm, really, the rejections or the conditional approvals may still give out such a strong signal that these would change the landscape. So the impact wouldn't be 39 out of 10,000, much like a mom and dad coming up with very good decisions, or at least good, let's not say good, but very consistent, predictable decisions where there is certainty in the household, but once every week, they are super inconsistent with what they have said just a week ago. Every week, once. That would still turn the whole thing into a very apathetical or a very undisciplined territory for the kids. If you were to keep stats of how many times they're passing a judgment and how many times they're contradicting with themselves, or the kids don't understand what's going on, that wouldn't be statistically a very significant thing, but the kids would take what they need to take out of it, which is that there's no justice, or that, this has hit us. So one has to be very careful with these statistical findings of problem in the sense that it diminishes the magnitude of the problem too much, in my view. Now, that said, innovation theories of harm in merger control is a new issue, and it's understandable why it is newish, let's say, in view of the history of antitrust in general. And if we were to summarize the European approach to it, what has been quite interesting is the line of Dow DuPont, ChemChina, Syngenta, and Bayer Monsanto. All cases that I have been involved in, so disclaimer. Also, I started writing my PhD thesis on this very topic, innovation considerations in merger control, right after these triage of cases. So maybe I was blinded with, oh my God, something's happening. And admittedly, it may not have happened that dramatically, because while 2017 was an incredibly dramatic year and things have followed afterwards, we haven't seen that many cases relying on the things that were relied on in that streak of cases. What was so special about Dow DuPont, ChemChina, Syngenta, and Bayer Monsanto? First of all, very early stages innovation was addressed, which was interesting. Discovery phase even. What would one expect? I'm also discussing this in the book quite a bit, the Innovation Paradox in Merger Control book. One would expect that the earlier the phase of innovation that you're addressing is in terms of concerns, the higher the standard of proof should be for the agency. because it becomes more speculative as you proceed to the earlier stages. I'm not going to relitigate these cases. All I'm saying is we're learning things from them. Another thing that is interesting for this triage is, especially Dow DuPont, but the others as well, we started touching an animal of innovation as such. We left the idea of having a product market necessarily for it, and we started focusing on the impact on innovation. And the Commission has been quite clear and direct with it as well. Later statements have even included a vocabulary like, we don't know the outcome of the innovation process in all cases, but we nevertheless know the innovation process would be harmed as a result of this merger. I'm not saying this sentence cannot live. All I'm saying is it's a very flamboyant sentence, and it would need to be backed up quite significantly with economic analysis. And that begged the question, which is something I'm discussing in the book as well, that begged the question of what kind of economic analysis. Now, when defense parties or merging entities' attorneys relied on general economic literature, this was typically dismissed by the Commission as narrative, speculative, you're talking about soft stuff. This is synergies. We need articulable, calculable, concrete stuff, right? But when the competition agencies were articulating the theories of harm in the innovation sphere, it has come down to assumptions quite frequently. Assumptions that mergers would be detrimental to innovation. There is a hypothetical innovation idea, and there is the horizontal merger impact on it. Now we're proceeding into a new phase, it seems, where more and more people, including agencies, are talking about case-by-case analysis of it, case-specific analysis of it, which is going to look a bit different than the language devoted for the theories of harm in cases like Dow DuPont, which relies on quite a bit of assumptions and a lot of same kinds of weapons used by the Defense Council being dismissed. So it is not articulable, it is not concrete enough when the applicant parties' attorneys use general economic literature, but more or less that's what the antitrust agencies are relying on as well, was the name of the game. What is changing now is that there is a bit more talk of counterfactual analysis, and there's a bit more talk on particularly a need for a different type of economic analysis. I'm about to publish an article with David Teese on this particular topic as well, where we're trying to cover the basis that there is actually a way of looking into innovation as such, and we need to. Beyond the overall, are we Schumpeterian or are we Arrowian kind of basic assumption-based approach. I'm not diminishing these two giants. All I'm saying is it's not enough on a specific case basis. Now we need a bit more complexity economics analysis. We need the understandings and the cultivated know-how of the business administration field in general that looks into what innovation is. And once that makes heavy inroads into the way of thinking of agencies and Defense Council, who are equally distant to it at the moment, because the quintessential economic analysis companies don't employ those bits of techniques yet. It will be possible to quantify the specific innovation impact of a merger in a specific market and to understand exactly what that innovation, not an idea of innovation, but that specific innovation in that field would take as an impact or not. Then we can see the contestability of the markets better. Then we can see issues of cannibalization effects, appropriability of innovation, and devoted to those markets in particular. At the moment, we're using a lot of literature on it, but ultimately it doesn't quite touched the ground as far as that specific market is concerned, especially when articulating theory of harm. Now, there is a particular critique that I would like to underline here as well, which is that more of the task, unfortunately, lies on the agencies, because the applying parties have only so much data. And there are also clean teams at work, which means there's only so much analysis that they can bring about the total impact to innovation of this particular concentration in that market. Which means if agencies have a predisposition of, oh my God, this is going to be bad for innovation because I can see some competing products in the pipeline, I should do something about it, it can easily go that direction. And a neutral starting point of analysis at the agency's side is therefore going to be quite critical in the analysis. Once that happens, a few things I think will be discounted as useful evidence a little bit. For example, there is an over-reliance on intra-company correspondence, in my view. We have dealt with quite a lot of evidences that related to intra-company email correspondences, which in my view were corporate chest thumping and not real. And yet there was heavy reliance on these. So at one side, one has to be fair to the competition agencies. They're articulating with economic literature. There's some sentimental factor there with the emails. What are they going to do? Are they going to fly over it? That's understood. It's an issue. But if you build an entire case on that corporate chest thumping, that may not give you the optimal result, and that may not be correct. So that requires an economic analysis of, is this real? Is this person's perception real? Is this person motivated to say these things to this particular email recipient for other reasons? And that is a holistic approach burden on the antitrust agencies, in my view, that they need to look at it from a total data perspective. And they would need to make sure that they get the particular nature of innovation in that market, which is quite frequently very zigzaggy. It's not a linear process, whereas it's treated as very linear in most cases, as if you feed R&D from one end, something happens, and you get the innovation at the other end. It's very zigzaggy. A lot of these efforts fail. There's a lot of risk that is taken. Depending on what market it is, innovation is fragile to certain factors, but it's not fragile to certain other factors. So specific innovation needs to be addressed, and that can only be done through the work of professionals going into this and interviewing people, and also through the business administration, strategic consultancy side of work that has been done as well. There's a last sentence, there's a problem there, obviously, which is while economics as a field has data underpinnings, and it is considered scientific the way things are approached, social science, but science still. It's not subjective like, say, law. Business administration is seen as soft. Yeah, some people are saying some things. This is their view. But we need to, I think, embrace the fact that the way it is used, competition economics has come to that point anyway. Two economists are saying exactly the opposite of what each other are saying with the exact same data set today anyway. So maybe we can expand the pool of information a little bit and open it up to people who are devoting quite some time and energy into innovation as such. being very careful that Georg and I aren't ganging up on Mark here, but I do agree that a couple of things can happen very easily if innovation as such is focused on, and it's innovation to innovation matters. It boils down to an instinct, boils down to a hunch almost. There's Annex 4 and there's a lot of work going in, no one denies that, but and it's not only a matter of Dow DuPont really, but in this field of innovation considerations in merger control, we're already bound to be a tad speculative because we're going to decide about something that may or may not happen in the future, which means we need to be extremely careful to make sure that we're not engaging in speculative scaremongering. If, by we, I say this time the EU, US, CMA, the established authorities. So I'm coming from Turkey, and the Turkish Competition Authority is quite an established authority. And I'm not extrapolating through the Turkish Competition Authority, but if you were to think of what this would lead in the emerging markets, if you don't have certain guidelines as to how you judge the innovation effects, and it's rather an idea of innovation that you're following, the emerging markets would pick that ball and run with it to places that the established antitrust agencies wouldn't even dream about. It would be so easy to write narratives and worries of things that will happen in the future potentially. So, and when you don't know what the product is going to be, it's very difficult to find a good balance of your focus between process innovation and product innovation. And it's very difficult to also focus on a term that we haven't used in this panel, which we should have probably, or maybe I was tasked to do it and I neglected it, innovation capacity. What happens to innovation capacity through this merger, right? And these are all, I think, foster childs of, or results of a basic understanding of innovation specific to the market, which is undisputed in the panel as well. But I am a bit more scared of this, we may not know the outcome of the innovation, but by God, I know a penalty when I see one. It comes down to that, right? But the football players don't understand what the referee will see as a penalty on the field. So the way they play changes is the problem. And excuse the football analogy, but my basic, therefore, principle here is we need more guiding principles and ways of looking into the specific innovation at hand so that it doesn't boil down to hunches of authorities or instincts of authorities. And Georg also used the word instinct, so that's why I wanted to underline that that's also a worry of mine. A couple of sentences. I'd also agree that probably if we're saying we need to move away from the conceptual protection of innovation, the innovation potential as such being protected as an idea, in terms of disruptive innovation, we should be double-glazed dubious about this because that's so difficult to touch. But it probably boils down to access, particularly access to data. For the students in the room, there's a very recent PhD thesis that just passed in Pantheon Assas. I was in the jury a couple of weeks ago. This is solely on disruptive innovation. What it is, how can we protect it, by Dr. Ayşe Gizem Yaşar. You might be interested in checking it out. There also, it comes down to basically the competition agency's best bet is to focus on complainants' complaints and defenses of the defending parties. Focus doesn't mean accept it, but at least get the first underpinnings of what rocks will be turned and where to look at through those real-life issues that are taken in the file, either by the complainants or the defendant may be coming in and saying, well, the condition you're imposing is actually going to be detrimental to and all that. It is rarer for the defendant to raise it as a point, obviously, because it's very rare that incumbents like disruptive innovation. So it is going to be highly likely that this is going to be in the hands of complainants. And staying open to the access foreclosure discussion, especially in the data side of things, will probably do the trick. But while disruptive innovation is extremely valuable and maybe the true engine of innovation really and economic growth really, it's as mystical as it is important at the moment. So I don't believe a crusade to protect it would lead to anything but perverse results. I think I had made the point that, you know, some of them could be corporate chest thumping and they shouldn't be favored too much. But definitely, I would agree that they're not nothing. Internal correspondence cannot be dispositive evidence of the theory of harm that is pursued by the agency, but it can easily be corroborating evidence, even more than that. Sometimes it can be providing color to what's happening and why this transaction is happening. It also depends on, you know, who is the party to the correspondence and all that. All I'm saying is when it is treated as an aha moment all the time, it may contain wrong leads, but it is an important piece of evidence, particularly in the capacity that you have presented, which is why are you paying all this money and what is it in it for you? So this is the true intention of the parties. It may be interesting there, yeah.
Sorry, can I just say that it is more than interesting? So I've worked with lots of boards of M&A, and if you're buying a $10 billion company and you're saying, well, actually, I'm now going to pay $14 billion for it, even though a day ago it was worth $10 billion. If you're putting that extra billion on the line for chest beating, you don't last very long. So it's really important, the rationale. The value creation is very top of mind in companies. So it is well documented, and you can really rely on it, just from my experience.
For the rationale of the transaction, I agree. If it's a board member who is involved in the making of the transaction, I agree. But we came to this conversation through Dow DuPont. And in Dow DuPont, it wasn't the case. So,
That's not my point.
Yeah, so my point was it can be, sometimes it can be quite dispositive, especially when it speaks to the rationale of the transaction. If it is internal company correspondence that is done by someone who is able to bind the company in that capacity, who is the raison d'etre of the transaction himself and all that. But if we're looking at aspirations of people in the company, lower ranking people, their hopes as to what's going to happen after the transaction in the marketplace and all that, then we need a pinch of salt. It's still not nothing, but then we need the pinch of salt, is all I'm saying.